Hello everyone. Now we are going to discuss the conceptual framework of geographical indication. And before delving into the discussion, we must first set the background that what this term essentially connotes and how you can figure out that what we are going to talk about. So as you all have already gone through with the discussion of trademarks, where indication of source also played a very, very important role. Likewise, in the case of geographical indication, those goods which have some sort of, you can say, embodiment, or you can say some sort of characteristic, which is very peculiar to some geographical region. And because of that geographical reason only, they acquire some sort of distinctiveness in form of quality, in form of characteristic, whatsoever. And because of that geographical affiliation, they are being appreciated much as compared to any other competing product. So it means to say that those goods which have some peculiarity because of geographical region, they were also needed to be protected under certain signs, because the main problem was that if no protection is given to these kind of products, then the producers who are producing in that very region would be easily carried away by various other imitators who can misappropriate that very good, and they can, misrepresent that it is coming from some other reason or something like that. So there are various, you can say, different kind of contingencies which may impact the concern or interest of those producers who were producing for long, and they have acquired that kind of distinction and appreciation because of those qualities. So because of that, we need that very protection which is distinctively recognizing the concern of those producers. And as you know, because it is very much embedded in the geographical region, so it means to say it is not only about protecting the property, but also recognizing the stake of those people who are producing something very, very distinct. So having said that, a geographical indication is a relatively new term, which has not been there, and it has been, introduced very, in TRIPS agreement only. Before that, they were known with a different connotation, that is appellation of origin. So why I'm comparing these things, it is very much required that you must understand the evolution of the protection of these kind of goods. So it was not like that, that it has not been protected with any sort of protection. It has been protected within a regime which take care of indications, various kind of indication of source, and you may be figuring it out very clearly that it was only the trademarks under which the goods were protected, and because of that, these indications were also, you can say, accommodated initially as a distinct kind of good having geographical connotations under various treaties. So what essentially is geographical indication? So as you know, it is an indication. You have to make distinction between two things. One is the good which is in question, and the other, the indications which are in question. So here goods have, they themselves have a kind of distinction as compared to other goods. Other goods may belong to any individual enterprise, but this very good belongs to certain geographical region, and not only it belongs there, but all the major attributes of that very good is being embedded in that very geographical region. And these goods are appreciated more because they are coming from that very region only. So it means to say that geographical position or geographical region plays a very, very important role as compared to any other feature. So geographical indication is a kind of sign used on products that have a specific geographical origin and they possess qualities or a reputation that are due to that origin. So in order to function as a GI, a sign must identify a product as originating in a given place. And in addition to that, the qualities, characteristics, or reputation of the product should be essentially due to the place of origin. Since the qualities depend on the geographical place of production, there is a clear link between the product and its original place of production. So under this very discussion, we will be getting into how GI has been developed and how it has been evolved. I will be just, giving a very, very brief overview of its evolution because we are more concerned with the geographical indication in India. But by being in a very, very, you can say, global world, where the global influences have a great meaning, we cannot be devoid of these international developments. Otherwise, you cannot fully grasp the geographical indications in India. So having said that, let's start with our discussion. So you might have seen these kind of indications on various products. So here, as you see in the case of trademarks, which could be a group of words, a picture, or you can say any sort of sign, symbol, group of words, and all that. So likewise, in picking up a particular geographical indication, you need to take the same caution as you take in the case of trademark that we will be catching up later on. So it looked like this, like you take the example of Darjeeling. So the word Darjeeling is there, which is also being claimed as GI, as well as there is a logo, which clearly, distinctively demonstrates what the sign or symbol is. So it clearly, distinctively give an indication that it is being protected for certain item, and that is here as the T. So product itself has distinction to that very reason, but it must also be backed by some sign which is clear enough, distinctive enough, and which could indicate what product it is indicating, or you can say referring to. So if you take the background, so any name which is associated throughout the word with products of certain nature and quality. And what is that certain nature or quality? So in all these traces, if you find, or if you go through, you will find that there is one common feature. And that common feature is geographical connotation. So one can say that their function of designating existing place, towns, regions, or countries. So may it be quality, may it be characteristic, may it be reputation. If it comes anywhere relating to these products, it must indicate some sort of, you can say, geographical place or town or region or countries. So for example, champagne is there, which indicates that it is coming from France. Havana is there, tequila is there, Darjeeling is there. Here one must not confuse that every time there is a place of name which must be there. It is not a kind of necessary, you can say, situation. There are situations where the term is very much embedded, or it has been very much, you can say, engrossed in a particular geographical region, and many people are being using that very term in different contexts, but it may not be peculiarly a name of a place. So like for example, basmati have some sort of generic meaning, which if you go into the origin, you will find etymology, you will find that it must have some sort of references to Hind or India, or you can say like this, a kind of indication where it has some traces which may reflect that people are understanding that very Basmati term here in India, and which indicates that any product which is associated with that very name must be embedded in that very geographical region. So one thing is that geographical names may be there, but sometimes some other, you can say, attributes may also be included, which are very popular in that very region. So geographical indications can acquire a high reputation and thus may be valuable commercial assets. So this gives you a kind of purpose which is required to protect a geographically indicated good. Why? Because these indications in due course of time, if they are attached with a particular good which is considered as a good which is related to certain geographical region, and it is being appreciated because it is originating in certain places. So because of that, these indications, if you provide to that very good, they may in due course of time becomes highly reputed. And once they become highly reputed, then they could be translated, or you can say better protected, as a valuable commercial assets. So this is a kind of, you can say, process which provides value to the product which is being produced in a particular geographical region. And the most important thing is that that very product which is being produced in that very geographical region is being claimed by a group of people, not a single individual. That I will be coming up later on. So in a way, it also protects a kind of community rights. So it is also, I mean, impacting those people who are producing something qualitatively, and it is being appreciated by many other parts of the world. And because of their quality, they are well in need for such kind of protection, which provides value to their product. So why we need this kind of protection? What was the basic reason why we have to invent these kind of, or you can say introduce these kind of protections? So there are always chances, as I have already mentioned, chances of misappropriation, counterfeiting, or forgery. So if the violation becomes inevitable, then you need law to check that very violations. Because of that, GI is very, very important. So if you go by the international agreements, so as I said that it has been a part of trade for a long time, and though the name was not there, geographical indication was not there, though it was not recognized as a very, very distinct good, but even then, within the realm of trademark, it has been given certain attributes or provided certain, you can say, special recognition because of its affiliation to certain geographical region. So it all started with the Paris Convention for the Protection of Industrial Property, 1883, as you know. This is the oldest treaty which covers the industrial property. And when I say industrial, it includes traditionally trademarks, patents, and industrial design. So here, this very good, which is recognized as geographically indicated goods, that was included or recognized under the Paris Convention in the form of trademark or under the regime of trademark for the protection of industrial property. Next system was also related to trademark classification, and since GI was not distinctively given a kind of independent, distinct protection, because of that, that was covered under trademark only. And it was but obvious that the extension of certain protection for the classification for trademarks was also applicable to the GIs. So Madrid system for the international registration of marks, 1891, was another international agreement which was there. Then came the Lisbon Agreement for the protection of appellations of origin and their international registration in 1958. So this was an agreement where you are clearly seeing or clearly make it out that the term appellation of origin has been distinctively mentioned in this very agreement. So this very agreement was the first attempt to recognize the protection of geographically indicated goods in a very, very separate and distinct form. So the Lisbon Agreement for the protection of appellation of origin and their international registration started in 1958. In this very chronology, the term got its place. The term, when I say the term means geographical indication. The first mentioning of this very connotation came into TRIPS Agreement 1994, where it has been recognized as one of the 7 distinctively mentioned intellectual property rights under the TRIPS Agreement. So this was a clear-cut recognition, or distinctively, providing a kind of protection in the form of distinct intellectual property right. After that, very recently in 2015, there was another attempt in the form of Geneva Act of the Lisbon Agreement on the appellation of origin and geographical indication 2015. So the peculiar thing in through this very act was to extend the Lisbon Agreement, which was just meant for appellations of origin, to geographical indications also. So that very registration process and other facilities which has been provided to the appellation of origin has been extended through this very agreement, which is known as Lisbon Agreement. So this is a kind of, you can say, international development or the chronological development of GI, which you can, frame in this manner. Now, as I said, that GI is a very relatively new term. So first we take how it was mentioned in Paris Convention. So in Paris Convention for the protection of industrial property, here you see that it does not contain the notion of geographical indication, but Article 1 and Para 2 of this very convention defines as subjects of industrial property. So first of all, it has been considered as a subject of industrial property, inter alia indication of source and appellations of origin. So here, though it was included in industrial property, but 2 kind of connotations have been used. One is indication of source and the other one is appellations of origin. So the appellation of origin was a term which accommodates, or you can say which recognized for the first time these specific goods which later on covered as geographically indicated. So indication of source, what does it mean and how it is different from appellation of origin? So indication of source is a very, very broad term, which could indicate just in a static way from where the good is coming from. So indication of source means any expression or sign used to indicate that a product or service originates in a country, a region, or a specific place. There is no other attribute that you find in the case of geographical indication that the goods character quality is being very much coming from some geographical origin. No such kind of a special affiliation which has been provided by indication of source. It simply provides what is the origin of that very product. Next thing, appellation of origin, which was later on defined in that very Lisbon Treaty when that was given a special protection. It was meant as the geographical name of a country, region, or a specific place which serves to designate a product originating therein, the characteristic qualities of which are due exclusively or essentially to the geographical environment, including natural or human factors, or both natural and human factors. So it means to say that here appellation of origin is giving a special focus that exclusively or essentially they must be derived from some geographical environment, and that geographical environment may not only be natural, it may be natural, it may be human, or it may be a combination of both. For example, if there is something, some goods which are just provided by the nature without having any special effort by the human being. So that could be a natural product which is being provided to that very geographical region. And because of that very geographical region, many things, many environmental factors are able to produce that kind of good. Next thing could be that people who are living there, they are using something, they are, I mean, producing something by their own skill, which is being highly, which provides some very, very distinct virtue, or you can say quality to that very product. And because of their effort, that is become valuable, or that is being appreciated by others. So in that very case, if it is being done solely by human being, that will be considered as a human contribution. So it may either be natural or human, or a combination of both. Take the example of Darjeeling tea or any other stuff where the cultivating methods may also be taken into consideration, and it could be considered as a combination of both. How farmers, I mean, making their attempt to cultivate that very crop of that tea, and how other factors like soil quality, the climatic conditions, how they are contributing in that. So that may be a combination of both. Take the example of Tirupati Laddu. In Tirupati Laddu case, the dominant factor, though you can, always you are dependent upon something which is coming as a raw material. So whatever raw material is required for the making of or manufacturing of laddu, that is coming from anywhere. But the process and method of making that very laddu is very, very distinct to those people who are making those laddus for a long time. And because of their method of making, it is being appreciated all around the country or many parts of the world. So because of that, that is peculiarly and in a dominant way a kind of human factor which is responsible for that. So you must be understanding all these things, like in all three ways a product could be very much appreciated because of that geographical origin. May it be human, may it be natural, may it be a combination of both. So the use of an appellation of origin requires a quality link between the product and its area of production. That quality link may be anything, may it be its aroma, may it be its taste, may it be its anything, which could be appreciated because it is coming from a certain geographical region. Like, for example, basmati rice, it's a long rice, there is a defined, parameters for that, and the aroma of that very rice is also very, very good. So because of that, people appreciate that. So that quality link is always attributed to the northern India and some parts of Pakistan, which is traditionally being, recognized that if there is a talk of basmati or there is a need of basmati, everybody is affiliating that it is coming from that part only. Even then, if you guarantee that the same thing is being produced by you, by being in any other part, people may not be, that much attracted to you because they have been using that very product and appreciating that very product which is coming from this part of the world. So the use of an appellation of origin requires a quality link between the product and its area of production. And this qualitative link consists of certain characteristics of the product which are exclusively or essentially, pay heed to these terms, exclusively or essentially attributable to its geographical origin, such as, for example, climate, soil, or traditional methods of production. So you cannot say that you are, producing something here, something there, and then claiming that it is coming from this very particular geographical region. You may not qualify for appellation of origin unless and until you will prove that it is being, all these characteristics, all these qualities are exclusively or essentially attributable to that very geographical region. So this is a peculiarity about the appellation of origin. So as you see, if you compare it in a very informal way, you can say that appellations of origin can be understood as a special kind of indication of source. So the term indication of source comprises all appellations of origin, but in its general sense, it has become rather a designation for those indication of source which are not considered to be appellation of origin. So because there is a special term, there is a special, you can say, connotation which has been recognized as appellation of origin. So if you peculiarly define something, then the other thing becomes, it has to be taken into a very, very general sense, apart from that very specially defined thing. So in due course of time, indication of source was used more for other thing rather than geographically indicated goods. So here we have to make a distinction between how it is distinct from trademarks. So there are various counts on which you can make a distinction. One of the count and one of the reason is as to the ownership, or you can say use. So a trademark identifies the enterprise, an individual enterprise, which offers certain products or services on the market. A geographical indication identifies a geographical area in which one or several enterprises are located and which produce the kind of product for which the geographical indication is used. So here you must say or make a distinction that in trademark, there is always an individual enterprise which is in question, but in geographical indication, there's a group of people who are there. And the indication of source is not limited or restricted to geographical region, but in case of geographical indication, there is a sign for none. That is always required. That is a peculiarity. And in this way, you can understand that GI is a very, very special kind of mark, or you can say indication, which is referring to some peculiar qualities of that product, which are indicating certain geographical region. So for example, in cases of trademark, indication of source is enough. May the product is being manufactured anywhere else, and there is no as such any limitation regarding that. Next thing is that there is no owner of geographical indication in the sense that one person or enterprise can exclude other person or enterprise from the use of geographical indication, but each and every enterprise which is located in the area to which the geographical indication refers has the right to use the said indication for the products originating in the said area. You can also make a distinction that in the case of geographical indication, which is only meant for protecting the goods, not services, but in the case of trademarks, it is provided for both. Next thing is that geographically indicated goods could be a part of various trademark holders if they are marketing that very product through different brands. But GI is a kind of prohibition as to the registrability of the trademark. So no trademark holder can use GI as their trademark, but they can use those products which are included under geographically indicated goods under different brands. So protection of geographical indication. Protection means the right to prevent unauthorized persons from using geographical indications, either for products which do not originate from the geographical place indicated or not complying with the prescribed quality standards. So as in the case of all the intellectual property rights, geographical indication is also a kind of exclusionary right. So what it excludes that only the authorized users of that very good can use it. Any other third party, if they are using it in any manner, two of the manner has been clearly mentioned here, then in that very case, there is a violation of those geographically indicated goods in the form of unauthorized use. So protection means what kind of right it provides? The right to prevent unauthorized persons from using geographical indications, either for products which do not originate from the geographical place indicated. I mean, you are just, giving a very false indication that it is produced or it is being originating from this place only, though it is being originating from some other place. or not complying with the prescribed quality standards. Or even if you are indicating properly, you are diluting the standard of that very product. So in both the ways, that could be violated. So protecting geographical indications against becoming generic expressions. So it is related to the distinctiveness of your geographical indication. So as you know, as in the case of trademark, you have been provided a protection which is perpetual in nature, subject to the condition that every 10 years, after 10 years, or within 10 years, you have to make a renewal, give a renewal fee and have to renew that very registration. So the same thing is applied here in the case of geographical indication also. So while selecting a geographical indication, one must be very cautious that it must not be a generic kind of, you can say, name, which people take it in a very generic sense. And the next thing is that though the protection which is being provided in both the cases, in trademarks as well as in geographical indications, are subject to 10 years renewal, and they must be proceeded likewise. But there is another limitation which come into effect. This is subject to another condition apart from that 10 years renewal subjection. That is, if it loses its distinctiveness, then that is lost. So when it loses its distinctiveness, one of the way is if it becomes generic. So how can you protect the GI from becoming a generic expression? So in this way, in that case, if that happens, they lost all their distinctiveness and consequently will lose their protection. So the question whether a geographical indication is a generic term and void of any protection is very subjective because of absence of international agreement to that very effect. And it is largely determined by the national law. It might well be that geographical name is regarded in one country as a geographical indication and is protected accordingly, whereas it is considered to be a generic or semi-generic term in any other country. So because of this territoriality, different countries have different kind of, you can say, treatment of a particular geographically indicated goods. For example, the best example you can find that there's a champagne and Chablis, these two products, which were only allowed to be used for products originating from certain geographical area and produced according to certain quality standards, whereas in the United States of America, they are regarded as being semi-generic names and therefore may be also used for wines not originating from the French area of production. So if you go by the geographical position of the United States of America, you will find that there is a Napa Valley in California, which is a wine hub. And sometimes what happens, how it becomes semi-generic, like if different kind of wines are being there, and in due course of time, people started recognizing that very product not as a geographically indicated good or not through their geographical affiliation, but because of their type of a kind of wine. So that becomes very generic, that this is a kind of wine. This is not a kind of a thing which is being coming from somewhere else. So because of that, that semi-generic name could be provided there, and it may create a kind of, you can say, obstacle in protecting that in United States. But because of that very principle, because of any robust, you can say, international treaty that has been going on. So this problem, though, has been dealt by Lisbon Agreement because there was no distinct treaty at that moment. So there was an effort by the world community that there must be something which distinctively take care of the registration of those kind of stuffs which are there, and they provide a kind of international registration to the member nations of that very agreement at least. So because of that, they tried to evolve a kind of treaty which is known as Lisbon Agreement for the protection of appellation of origin and their international registration. As the name itself suggests, it was an attempt to provide a kind of international registration. So what essentially it provides? It lays down provisions for what qualifies as an appellation of origin, protection measures, and establishes an international register of appellation of origin, which is to be run by the WIPO. So this kind of mechanism where various appellations of origins could be properly regulated, that what qualify them as an appellation of origin, what protection measures are being there, and after that, after ensuring that, that could be entered in that very international registration of appellation of origin. Another thing was that the agreement came into force in 1966 and was revised at Stockholm 1967 through various amendments which happened in 1979 and 2015. On May 2015, so the number of states you might see, there are very less states. That is, on May 2015, 30 states are party to the convention, and 1,000 appellation of origin has been registered. So it ensures that in member countries, appellation of origin receives protection when are protected in their country of origin. So if you seek protection in any other country, member country, you must first of all protect it in your own country. So that was a kind of precondition which was maintained under this very agreement. So the agreement also establishes a special union under Article 19 of the Paris Convention 1883. So after this very agreement, the major development was the TRIPS agreement, which has used the term geographical indication and classifies geographical indication, as I told you, a distinct form of intellectual property rights under it. So some aspects of this very Lisbon agreement have been superseded by TRIPS agreement. So Lisbon agreement, as I told you, has clarified, because it was devoted to protect appellation of origin. So it was but obvious that it must provide a kind of definition to it. So it provides that definition in such a manner that the geographical denomination of a country, region, or locality, which serves to designate a product originating therein, the quality or characteristics, and one thing you always bear in mind that one thing is missing from here. If you compare it, this definition to the definition which is being given in the TRIPS. So the term reputation is not being used. So here you must again go through it. The geographical denomination of a country, region, or locality, which serves to designate a product originating therein, the quality or characteristics of which are due exclusively or essentially to the geographical environment, including natural and human factors. So first of all, quality and characteristic, and those quality and characteristics must be exclusively or essentially embedded in that very geographical environment. So here we must have to be very, very attentive when we make a distinction how appellation of origin is different from geographical indication. That will help you to understand. Next comes the TRIPS agreement. So if you go by the TRIPS agreement, you will find that under Article 22, protection of geographical indications have been mentioned. And here you will find how it has been defined. Sorry. So Article 22, Clause 1, it defines geographical indications. For the purpose of this agreement, these indications meant the indications which identify a good as originating in the territory of a member, or a region or locality in that territory. First of all, who are the member nations of WTO? So what it is referring to, these indications which identify a good, so that must be a kind of qualification for that indication, that it must refer to or identify a good as originating in the territory of a member, or a region or locality in that territory where a given quality, reputation, or other characteristic. So it is all inclusive. There may be many things which could be attributed to this. So a given quality, reputation, or other characteristics of the good is essentially attributable to its geographical origin. In respect of geographical indications, members shall provide the legal means for interested parties. So it is a kind of obligation also. If you are a member to WTO, then you must ensure that. What you have to ensure that in respect of geographical indications, members shall provide the legal means for interested parties to prevent, number one, the use of any means in the designation or presentation of a good that indicates or suggests that the good in question originates in a geographical area other than the true place of origin in a manner. So this is a kind of action which is objectionable, which could be considered violative, and against this the protection could be given. So the good in question originates in a geographical area other than the true place of origin in a manner which misleads the public as to the geographical origin of the good. So there must not be any misleading attempt which could give a kind of impression that the thing is originating somewhere else as regards to its true place of origin, or any use which constitute an act of unfair competition within the meaning of Article 10 BIS of the Paris Convention. So first thing which you have to ensure is that the parties must be protected against misleading kind of, you can say, indication. And the next thing is you can also ensure that any use which is being done in such a way must not be an act of unfair competition within the meaning of Article 10 BIS of the Paris Convention. Subclause 3 says a member shall ex officio, if its legislation so permits, or at the request of an interested party, refuse or invalidate the registration of a trademark which contains or consists of a geographical indication with respect to goods not originating in the territory indicated, if use of the indication in the trademark for such goods in that member is of such a nature as to mislead the public as to the true place of origin. So here they are casting a kind of duty over the member nations also. And here we must also understand that these kind of protections are given in a very voluntary manner. So like if its legislation so permits. So there are two kinds of protection, I must tell you, that is going through the whole world. And one protection is under the common law way, where protections are being in a very, very different framework, not that much strictly defined framework. And there are other countries like European countries, India and many others, they are taking up it in a sui generis way through the various legislations, as India has Protection of Geographically Indicated Goods Registration and Protection and Registration Act 1999. So that thing is not in place in US, even in Australia, you don't find that kind of protection. So because of that, there is a kind of two models which are running, and countries are free to adopt any model. But European Union is pushing for this sui generis model in different ways, influencing or in a way exerting influence for other countries. So a member shall ex officio if its legislation so permits, or at the request of an interested party, in both the ways. If you are requested, or even if you are ex officio, you can act like that. So refuse or invalidate the registration of a trademark which contains or consists of a geographical indication with respect to goods not originating in the territory indicated, if use of the indication in the trademark of such goods in that member is of such a nature as to mislead the public as to the true place of origin. So no confusion with the trademark 2. Fourth thing is the protection under paragraphs 1, 2, and 3 shall be applicable against a geographical indication which, although literally true as to the territory, region, or locality in which the goods originate, falsely represents to the public that the goods originate in any other territory. Now coming to some special protections, which are sometimes, become controversial. It becomes controversial because some additional protection has been provided to some special goods, which are mostly a part of developed countries rather than developing countries in that way. And that is why developing countries raise that kind of issue that we must also be given some same kind of additional protection in cases of infringement too. So what is this, you can say, additional protection? So if you go by Article 23, additional protection for geographical indication for wines and spirits. So these are two items which has been protected additionally. So what they essentially are: each member shall provide the legal means for interested parties to prevent use of a geographical indication, identifying wines for wines not originating in the place indicated by the geographical indication in question, or identifying spirits for spirits not originating in the place indicated by geographical indication in question, even where the true origin of the goods is indicated or the geographical indication is used in translation or accompanied by expressions such as kind, type, style, imitation, or the like. So the distinctiveness which is being strictly attributed to other goods of geographical indication, here they are liberating that kind of, you can say, condition, and they try to encompass some nearby things also, while mentioning this thing that even where the true origin of the goods is indicated or the geographical indication is used in the translation or accompanied by expressions such as kind, type, style, imitation, or the like. And the second thing is that the registration of a trademark for wines which contains or consists of a geographical indication identifying wines of or spirits which contains or consists of a geographical indication identifying spirits shall be refused or invalidated ex officio if a member's legislation so permits or at the request of an interested party with respect to such wines or spirits not having its origin. Now, subclause 3, what it says that in the case of homonymous geographical indications for wines, protection shall be accorded to each indication subject to the provision of paragraph 4 of Article 22. Each member shall determine the practical conditions under which the homonymous indications in question will be differentiated from each other, taking into account the need to ensure equitable treatment of the producers concerned and that consumers are not misled. So if you have certain safeguards, even you can accommodate homonymous indications too. Paragraph 4 says, in order to facilitate the protection of geographical indication for wines, negotiations shall be undertaken in the Council for TRIPS concerning the establishment of a multilateral system of notification and registration of geographical indications for wines eligible for protection in those member participating in the system. So these are the various measures which has been given in the form of special, you can say, protection or additional protection to wines and spirits. So that could be another discussion which we will take up if we will discuss separately. But that is a kind of, you can say, evolution, or you can say a kind of chronology, which you can understand that how GI has been evolved, how it has been taken care of under various agreements, and how it has been substantiated in various agreements, and it has been concretized in TRIPS. And there is another, as you see, next attempt which has been made under the Lisbon Agreement. So this is a background which we must set, and as I told you that there were two choices: either you go by the common law system or you can have a sui generis protection to ensure the you can say, interest of those people who are producing these kind of goods. So what happened to our legislation and how we proceeded? So let us focus upon that. So the Geographical Indication of Goods Registration and Protection Act 99 came into picture. And it was not only because of the TRIPS obligation, but certain violations also, which came in the form of basmati, case episode, and many other things. Though we have registered Darjeeling tea as our first, you can say, GI, but before that also, as I told you that it was not like that, that the stuffs like Darjeeling tea were unprotected before this GI act. They were protected in the form of certification marks and collective marks. So in certification marks, T board has evolved a kind of mechanism where it ensures that whatever tea is being exported to any other country must have certain features which are defined standards by that very board only. So when it certifies that the goods which are coming to it for that very export, they must be authenticated by the comparison that they match up with the quality which is prescribed by them. So in that way, it has been carried on for a long time, and still in few countries we have protected, you can say, this thing, Darjeeling tea, through certification marks only. So these are the varying attempts which one can make because of the dual form of protection which has been allowed under this very regime. So let's start with this. It came into 1999, but it was given effect only in 2003. So though it has been evolved in 1999, but there was a kind of delay in effectuating it. So what is the purpose behind it? The purpose behind it, I have already mentioned, to provide for the registration and better protection of geographical indication relating to goods. And if you compare the situation of India and the countries like India, you will find that geographically indicated goods are a kind of community rights which are always attached to that. And there are people, it's part of, you can say, a kind of culture which we have. It is embedded in our cultural traditions through which we have been able to produce something which is very much appreciable. So it became very, very important to give protection to stakeholders which are really producing it. There are many issues. We cannot say that by just enacting this very act we have solved all these problems. There's a kind of attempt which we made, but there are many issues, very serious issues, which are involved in effectuating this geographical indication. Whether the benefit is going to those stakeholders or not, whether the attempts are being made properly to take concern of those producers or not, what kind of producers you are eyeing on, what kind of producers are being given priority, whether that process is inclusive enough or not. So there are so many questions. That questions are practical questions which are with every legislation, and this is not an exception. But at least we started recognizing the rights of those people, and it could help in sustaining their production. And there are various other attributes to this very geographical indication where it ensures green innovation also, like because the goods which are largely accommodated under geographical indications are agricultural goods, or the goods which are produced manually by many people, or you can say in a very traditional way. So in that way, they are also attached to traditional knowledge too. And when you recognize these things, they must impact those people also. So in a way that it is more attuned to green innovation, it is more attuned to sustainable growth or such as sustainable production. And it is also a kind of recognition for those people who are in chain of that reproduction for a long time, from generation to generation. So having said that, let's start with this very framework, that is geographical indication in India. So Just catch up few definitions. One of the definition which is being given here is deceptive similarity, which is being recognized under trademark also. So when you pick up any mark for the protection of your geographically indicated goods, you must ensure that a geographical indication shall be deemed to be deceptively similar to another geographical indication if it so nearly resembles that other geographical indication as to be likely to deceive or cause confusion. So as likewise, a more akin definition to, akin to trademark law. Next thing is very important is section 2E. One must always remember. This has defined geographical indication, and it is a very, you can say, a little enlarged definition as compared to the definition which is provided in the TRIPS. So how it defines geographical indication? So here geographical indication has been defined like this. Geographical indication in relation to goods means an indication which identifies such goods as agricultural goods, natural goods, or manufactured goods as originating or manufactured in the territory of a country or a region or locality in that territory where a given quality, reputation, or other characteristic of such goods is essentially attributable to its geographical origin. And in case where such goods are manufactured goods, one of the activities of either the production or processing or preparation of the goods concerned take place in such territory, region, or locality as the case may be. So let's fragmentize, or you can say, take it one by one, that what it indicates. So it indicates an indication which identifies such goods as how many kind of goods you are accommodating. It identifies either agricultural goods or natural goods or manufactured goods. Three distinct categories of goods are being accommodated under the geographical indication. And what would be the peculiar feature of those goods? Those goods as originating or manufactured in the territory of a country or a region or a locality in the territory, where what kind of attributes it is deriving from that very region, where a given quality, reputation, or other characteristic of such goods is essentially attributable to its geographical origin. And in case where such goods are manufactured goods, so the categories are already defined. So if it is a manufactured goods, one of the activities of either the production or of processing or preparation of the goods concerned take place in such territory, region, or locality as the case may be. So it is not necessary that all these activities must be carried on in that very geographical region in case of manufactured good. There may be either one of the, activities must, be taken care of in that very territory. So for purposes of this clause, any name which is not the name of a country, region, or locality of that country shall also be considered as a geographical indication if it relates to a specific geographical area and is used upon or in relation to particular goods originating from the country, region, or locality as the case may be. How goods are defined? Goods means any agricultural, natural, or manufactured goods, or any goods of handicraft or of industry, and includes food stuff too. So this inclusive definition of good. And then comes indication. What the term indication means? It means any name, geographical or figurative representation. You might have seen, and you have seen that Darjeeling tea mark, so you will find the figurative representation or any combination of them conveying or suggesting the geographical origin of goods to which it applies. Name includes any abbreviation of name also. Package includes any case, box, container, covering, folder, receptacle, vessel, casket, bottle, wrapper, label, brand, ticket, reel, frame, capsule, cap, lid, stopper, and cork. Here is a very important definition that is in 2K. So after going through what the term geographical indication connotes in the Indian Act, that is geographically indicated indication of goods Act, you have also to remember what the term producer means here. So producer in relation to goods means any person who, if such goods are agricultural goods, produces the goods, and includes the person who processes or packages such goods. So it is not only that person who is just producing it, but also those who are giving effect to processing or packaging, they are also being included under producer, and whatever benefit, whatever protection is being provided to producer must also extend to these people too. Second thing is, if such goods are natural goods, they have only to exploit that goods. No other attempt is required. So in the cases of natural goods, they must exploit the goods. And third one is, if such goods are handicraft or industrial goods, makes or manufacture the goods and includes any person who trades or deals in such production, exploitation, making or manufacturing, as the case may be, of the goods. So it is also all inclusive. It includes many things like manufacturing, making, and the trading or dealing and everything in that very process. Now that is the producer. Who is a registered proprietor? So registered proprietor in relation to a geographical indication means any association of persons or of producers or any organization for the time being entered in the register as proprietor of the geographical indication. So here we are talking about the registration of, registered geographical indications. So one thing we must understand here, that when it comes to registered proprietor, it is always the group or a collective entity which is the proprietor of this kind of goods, not a single individual. I mean, one individual cannot go and ask for that very geographical indication to be registered in his own name as a registered proprietor. So whenever and wherever there is a case of registered proprietors registration, so in relation to geographical indication, it only means any association of person or of producers, or association of person, association of producers, or any organization for the time being entered in the register as a proprietor of geographical indication. So sometimes what happens, like in some cases, some sort of goods which are not that much affiliated to these kind of people who are being claiming for their rights, or you can say for their ownership. There are certain areas also where state exerts that very control because of this absence, and in that very case, some organizations may also be taking care of that very product, and that very sense that organization may come also to be registered as a proprietor. So tribunal means the registrar, or as the case may be, the appellate board before which the proceeding concerned is pending. Then who is the registrar? The Controller General of Patent Design and Trademark, appointed under this section. I mean, the Controller General of Patent Design and Trademark is shall be registrar of the geographical indication. So he is also being given this very responsibility too. Who are the other officers? The central government may appoint such officers with such designation as it may think fit for the purposes of discharging and the superintendent and direction of the registrar such functions of the Registrar Act. Registrars shall have the power to withdraw or transfer cases, etc., regarding matters pending before an officer. Head office, it has been given to the central government that as it decides, so it has decided that its head office will be in Chennai. So now the head office of geographical indication is in Chennai. So there is a determination of territorial limits also. So it is also being empowered through the central government. I mean, central government is empowered by, and it may by notification also determines the territorial limits within which an office of GI registry may exercise its function. So as you know that in recent times, all the intellectual property rights are being clubbed together and they are being placed together. So for example, if you go by the IP office of Dwarka, which is for Delhi and the North region, so you will find that all the offices, may it be copyright, may it be trademark, may it be patents, may it be GI, they are all are located in the IP office. So central government by notification also determines the territorial limit within which an office of the GI registry may exercise its function. And this GI registry carries a seal also. Section 6 talks about that the register shall be kept at the head office of the Geographical Indications Registry, wherein shall be entered all registered geographical indications with names, addresses, and descriptions of the proprietors, the name, addresses, and descriptions of authorized users, and such other matters relating to registered geographical indications. And many other stuffs has been detailed into that very register. The register shall be kept at each branch office of the geographical indication. So, first of all, the register shall be kept under the control and management of the registrar, and the register shall be kept at each branch offices of the geographical indications to look into that and do the registration. Now comes what is the framework of this register? So there are two parts, part A and part B. So under part A, the particulars relating to the registration of the geographical indication shall be incorporated and form part of a part A of the register in the prescribed manner. So here, what is included? The registration of the geographical indications. What about their claimants? What about their the people who are using it? So the particulars relating to the registration of the authorized users shall be incorporated and form part of part B of the register in the prescribed. And it is because of the convenience also, like one is a very stable thing that once you get registration of that geographical indication, that settled. But settled in a sense that in case of authorized users, many may come and go out. I mean, many could be added upon. So two different kind of, you can say, categories were required, and that makes sense also. So registration to be in respect of particular goods and area. So a geographical indication may be registered in respect of any or all of the goods comprised in such class of goods as may be classified by the registrar, and in respect of a definite territory of a country or a region. So as you see in the cases of trademarks, there is some sort of classification for the goods. Like classification is also being made here in the case of GI, because GI is very much particular about the geographical region. So it is but obvious that the classification could be made in a way where such class of goods as may be classified by the registrar, and in respect of definite territory of a country or a region or a locality in that territory on the case basis. So the registrar shall classify the goods under subsection 1 as far as may be in accordance with the international classification of goods for the purposes of registration of geographical indication. So they try to comply with the international classification of goods. The other guideline, other thing which has been mentioned here is that the registrar may publish in the prescribed manner an alphabetical index of classification of goods referred to in subsection 2. So registration to be in respect of particular goods and area which we are dealing with. So here any question, I mean that classification has been made and goods have been registered. So if any question arising as to the class within which any goods fall or in the definite area as referred to in subsection 1, in respect of which the geographical indication is to be registered, or where any goods are not specified in the alphabetical index of goods published under subsection 3, shall be determined by the registrar. So here the full authority has been given to the registrar that in case of any sort of question as to the registrability of that very product in a particular category or in a particular class, the decision of or the determination of the registrar would be final. So these are the things how this has been, register has been classified, how registrar has been empowered to make a decision to classify the goods. Now we are coming to certain indications which are prohibited from registration. This is a, if you compare it with the trademark, you will also find that trademark also mentions certain marks which are not registrable. So what are these here in this very case? A geographical indication, the use of which would be likely to deceive or cause confusion. So deceptive syndrome. Second thing is the use of which would be contrary to any law for the time being in force. So it is violative of any law. Third thing is which comprises or contains scandalous or obscene matter. So some sort of, you can say, a moral content has been attributed to this. And the last one is which comprise or contains any matter likely to hurt the religious susceptibilities of any class or sections of citizens of India. Further, which would otherwise be disentitled to protection in a court. So there, if there is some other considerations which could disqualify that very mark in a court. Next, which are determined to be generic names or indication of goods and are therefore not or cease to be protected in their country of origin, or which have fallen into disuse in that country. So all these determinations could be taken into account, consideration could be taken into account, and which, although literally true as to the territory, region, or locality in which the goods originates, but falsely represent to the persons that the goods originate in another territory, region, or locality, as the case may be, shall not be registered as a geographical indication. So there's an elaborative list, I mean, which could be checked that whether they are allowed or they are prohibited. So one can say that there's a very exhaustive, you can say, list which is being provided to exclude the various indications which are applied for geographically indicated goods. So prohibition of registration of certain geographical indication, what explanation says. For the purposes of this section, what the term generic means in relation to goods means the name of goods which, although relates to the place or the origin where the goods was originally produced or manufactured, has lost its original meaning and has become the common name. So as I told you that champagne, if it designates, or if it starts, I mean, like that people always affiliate it to be coming from France. But in due course of time, if its use is like that people have forgot that from where it is coming, they are just realizing that it is being produced here in some part of US or something like that. And in that very case, that very affiliation, or you can say appreciation in terms of place, has been lost. And because of that, they has lost its original meaning and has become the common name of such goods or type of that very goods, and serves as a designation for an indication of the kind, nature, type, or other property or characteristic of the goods. Explanation 2 says that in determining whether the name has become generic, account shall be taken of all factors, including the existing situation in the region or place in which the name originates and the area of consumption of the goods. Now just we will pick up a few other important aspects and we will carry our discussion in the next lecture, but I will try to accommodate this very section. So application for registration, who can make the application? It's very, very important. So who can apply? Any association of persons or producers or any organization or authority established by or under any law for the time being in force, representing the interest of the producers of the concerned goods. So any association of person can apply, any association of producers can apply, or any organization can apply, or any authority established by or under the law for the time being in force representing the interest of producers of the concerned goods, they can apply, who are desirous of registering a geographical indication in relation to such goods shall apply in writing to the registrar in such form and in such manner and accompanied by such fees as may be prescribed for the registration of the geographical indication. So it hasn't provided, I mean, it was the kind of enabling locus standi. It's not a kind of a very rigid locus standi where only the person who is affected can apply. Many entities can apply, and they can take care of various vulnerable groups which cannot apply on their own also. So this is who can apply. The application under shall contain what it contains. A statement as to how the geographical indication serves to designate the goods as originating from the concerned territory of the country or region or locality in the country, as the case may be, in respect of specific quality, reputation, or the characteristics of which are due exclusively or essentially to the geographical environment with its inherent natural and human factors, and the production, processing, or preparation of which takes place in such territory, region, or locality as the case may be. So simply they have to indicate all the attributes which are necessary for qualifying as a geographically indicated geographical indication for certain kind of goods. So in that regard, they have to make a statement that how these qualifications could be met. Next thing what they have to do is they have to define the class of goods to which the geographical indication shall apply. Next thing is that the geographical map of the territory of the country or region or locality in the country in which the goods originate or are being manufactured. So they have to mention class of goods, then they have to mention provide the geographical map where it is originated. Why that is there? Because the essence of geographically indicated goods is that very geographical area. So it is very much important in this very case that that must be provided. Then the particulars regarding the appearance of the geographical indication as to whether it is comprised of the words or figurative elements. So the nature and the characteristic of the indication which you have selected for those goods, you have to make it clear. And you have to provide the particulars of that. For example, if you are indicating or using some sort of figurative element, you must provide that kind of, kind of a particular regarding that. A statement containing such particulars of the producers of the concerned goods, if any, proposed to be initially registered with the registration of the geographical indication as may be prescribed, and such other particulars as may be prescribed. A single application may be made for registration of a geographical indication for different classes of goods, and fee payable therefore shall be in respect of each such class of goods. So you cannot combine many of your goods and try to have only one application. You have to apply differently, distinctively for different classes of goods. Next thing is every application shall be filed in the office of the geographical indication registry within whose territorial limit the territory of the country or the region or locality in the country to which the geographical indication relates is situated. So, I mean, you just go by your defined territorial jurisdiction and you must proceed with that with the office only. Provided that where such territory, region, or locality as the case may be is not situated in India, the application shall be filed in the office of the geographical indication registry within whose territorial limits the place mentioned in the address of for services in India as disclosed in the application is situated. It is a very common, you can say, condition which is being applicable in other aspects also. So here I'm just stopping my lecture to the content of the application. Now, what is the registration process and how other things could be defined, that I will be catching up in my next lecture. So I hope that I have provided a kind of sense regarding 3-4 things which I must mention. First of all, what are geographical indications? So if you go by the definition, then first you got the definition of appellation of origin, which was providing exclusivity in terms of all the attributes which must occur at one place only. While in geographical indication, you will find that there is some sort of liberty as to that very place. And in some manufactured goods, you have found that there may be one, at least one activity must be running at a particular place. It is not essential that all these things will be just going in one place. So appellation of origin has been defined in the Lisbon agreement, and then you will find that that has been redefined in the TRIPS agreement, where it has been categorically defined through the addition of one more word, that is reputation, along with quality and character. And the next definition we will find, I mean, that was the definition which is running right now. And two kind of models, as I said, that the common law model and the sui generis model is being operating in the world, and has adopted that very sui generis model, and we came up with that very act only. And under section, that very section 2E, we will find that how India defines geographical indication in three very categorical sense, like natural, human, or a combination of both. So I mean agriculture and human, and that way. So agriculture has been, I mean, peculiarly mentioned in the definition of geographical indication here. And then we discussed that how various provisions define the various attributes of geographically indicated goods as well as geographical indication. And then how offices are being established, and then how one can move with the application, what is the content of the application. So I hope that you can have a kind of understanding of the basics of geographical indication. And with this, we can move further in a very conducive way. So thank you very much for this lecture, and we will be catching up with other aspects in the next lecture. Thank you very much.